All right, so welcome to Online Media Law and Ethics. First off, I hope nobody read any sort of anger or annoyance or anything like that into the decision, my announcement that we're going online. It's just reality, right? I think everybody's just trying to get through the semester in whatever way is best. And the class as a whole has made the decision that doing it online seems to work better for everybody. So that's what we're going to do until the end of the semester, which I believe we have about 4 or 5 more weeks worth of lectures. Actually, probably less than that, about 4 weeks of lectures left, and then we'll start our final project. So I'm excited to get everything. Really feels like we're trying to kind of hit the home stretch, which I'm really excited about. So I'm going to post an announcement for those of you who aren't here, and we are going to be doing the legal analysis rewrite. Those will be due next week, so you'll have about a week and a half to do them. Again, if you have any questions about the legal analysis, I know that some of you guys struggled with it, or if you haven't done the legal analysis, let me know. While I didn't give anybody specific feedback who turned it in late, I am happy to answer any questions that you have. Again, I would love to give everybody in this class an A. I take absolutely no joy in giving back grades. So whatever I can do to help you out, please let me know. All right, so yeah, Jalen, go ahead. Go ahead, Jalen. Unless you're typing it in chat.
Oh shoot, what happened? Can you hear me?
Yeah, I can. Go ahead.
Okay, I don't know what happened. But did you say it was a new legal analysis or a redo of the previous ones?
No, so it's a good question. Redo of the old one. Essentially, the legal analysis that you turned in was a graded rough draft. So it allows you to take all my notes, hopefully improve, and then you get the higher of the 2 grades. I sincerely hope that the higher of the 2 grades is going to be your second one. Otherwise, you have gone well off the beaten path, in which case I'll keep your first grade. So again, the notes are still there. One of the main problems that I saw with people is not that people had the answer incorrect. Most of the time the answer was correct. The issue was the not following the legal structure and not fully explaining everything. So if you have any questions about it, let me know. But yeah, no, same one that it was. You're just essentially doing a rewrite of it if you're not. And if you're happy with your grade, you don't have to resubmit it. Okay, so if you got a B plus and you are all about a B plus to the semester, you just don't want to worry about it again, that's fine. I don't care. Just go ahead and be happy with that, okay? All right, so I don't know why I say okay, thinking that anybody's going to respond because you guys are all online. So what we're going to do today is finish up our conversation about right of publicity, the ability for celebrities to monetize their likeness. So I left you guys last class 5 days ago, seems like forever, with a question. I showed you a Jay Pharoah clip from SNL. It is a few years old, but really, I think is a really good example of celebrity impersonators, people who can really imitate those voices and make a living doing that. And I asked you guys if Cat Williams or Kevin Hart or Dave Chappelle got upset with their portrayal or got upset that somebody was imitating their voice, could they sue for right of publicity? And as we talked about, right, imitations can theoretically infringe on somebody's right to monetize their likeness because a voice is part of their likeness. We saw that with Bette Midler. So why? And I have it pulled up right now. I have the test, the thing that says all the things you need to prove in order to win a right of publicity case. Now, I understand it's online, not the easiest mechanism for back and forth discussion, but can anybody tell me why Cat Williams, if he wanted to, could not sue Jay Pharoah for violating his right of publicity? Which thing is not met?
The financial injury.
Okay, possibly, right? Financial injury, right? There is, how much is Cat Williams losing out by Jay Pharoah doing a impersonation? And heck, for all we know, this is going to be something good for him, right? When you're made fun of by SNL, in a lot of ways, you've made it. Okay, so that might be an answer. Can we think of another reason why Cat Williams or Kevin Hart wouldn't be able to sue?
It wasn't for a commercial advantage. It was just for entertainment.
Exactly. And both of you guys are right. Kylie, I think you might be a little bit more. I think that might be a little bit of a stronger argument, right? When Jay Pharoah is doing the impersonations, the benefit that is going to SNL and to Jay Pharoah is more expressive, right? It's there's comedy value there. There's societal value, right? Like, I think it was very lighthearted, but they're making fun of Kevin Hart. They're making fun of Dave Chappelle. They're making fun of these people a little bit, and so there's a parody value to there as well. It's really important that you guys know, because this goes back to our conversation about commercial speech. Commercial advantage means really, in a lot of ways, it means advertising. Yes, SNL is going to make money. NBC is going to make money. Heck, Jay Pharoah is going to make money off of this. But in the same way that a newspaper can make money, or a film or documentary can make money. So look at it more. Let's take a documentary, for example. Trying to think of a good one. Tiger King. Didn't see Tiger King. Heard it was weird. But the Joe Exotic stuff from way back when this whole pandemic thing started, which feels like a million years ago. When they made the movie about Joe Exotic, they were using his likeness. They were using his voice and his face, and and Tiger King, Netflix and the producers of Tiger King got a financial advantage from that. However, it's not going to be, Joe Exotic would not be able to sue for right publicity, because the interest is more expressive. It's more being a documentary than it is simply advertising. And that's what commercial speech. It doesn't mean making money off of. It means buy my good or service, buy my product, in the way that celebrity endorsements are known to do. Okay, let's move to these. Right, and that is going to be the first offense that we talk about. The first offense that we talk about is the ones that are reserved for expressive works. Expressive works are works that use a celebrity's name, likeness, persona in motion pictures, books, magazines, and other expressive works. Essentially, if you are making something that is artistic, that also might be, or for the purpose of news gathering, or for educating the public, or education, or scientific research, right? Things other than I would like to make money, please. Okay, if you can add on that additional, interest, that additional societal advantage that comes from using celebrities' likeness, then you're probably in the clear. Additionally, if you are advertising an expressive work, so I have Steve Jobs up here, the movie that came out a few years ago with Michael Fassbender as Steve Jobs, right? Obviously, making a movie about Steve Jobs is going to be an expressive work. It's a movie, it's dramatization of a guy's life. Now, it wouldn't make a lot of sense that somebody would be able to make a movie about somebody, but then not be able to tell people about it, or not be able to advertise about it. So advertising about an expressive work is also going to be constitutionally protected. Now, if you tried to run a billboard that says Steve Jobs was a big fan of Gatorade, right? And put Steve Jobs face up on a Gatorade ad, well, that's going to be slightly different, right? We're only talking about expressive works. So this brings up a really important point, and it's something that you oftentimes see as a misconception. It's one of those kind of super annoying legal misconceptions that just for whatever reason will not go away. There is no such thing technically as life rights. And so you'll see this when people say, well, we got the rights to make a movie based on somebody's life, or we got the rights to this story, and somebody sells their heroic whatever to a film producer and they produce it. This is not required, and it is not illegal to make a movie about somebody's life without their consent. Because as we'll see, it's an expressive work, right? So it's not going to come into right of publicity, and it's also not going to be copyrightable. We'll talk about that either at the end of this class or next class when we get to copyright. But why? But studios still are going to require them more often than not. There's a funny 30 Rock thing about they're trying to make a movie about Janis Joplin but can't get the life rights, so they call her Jackie Jorm Jump, right? You kind of like a amalgamation or a close simile to Janis Joplin. So the question becomes, well, why do they do this then? Like, life rights contracts are a thing. And so I'm not saying that they're not. So if you ever hear, somebody needing a life rights contract, you don't tell them, actually, you're full of crap because my media law professor back in my junior year told me that life rights aren't a thing. Well, okay. They are not required under either copyright or right of publicity. However, there are reasons that studios will oftentimes require the consent of somebody before they're going to make a movie about their life. These can include defamation concerns. So we're going to watch Social Network a little. I think we're going to watch it next week. And obviously, Mark Zuckerberg is not going to be a big fan of how he is portrayed in that movie. And if he wanted to and felt like he had a good enough case, he could have theoretically filed a defamation suit against the studio, against the director, against the filmmakers. And even if it's a frivolous lawsuit, studios are going to be very cautious to go through anything that they might expose them to litigation, not only from the cost perspective, but one of the things that can happen when we're talking about defamation, it doesn't happen often, but it's enough where you want to be concerned about it, is that they can put a hold on the movie. And so all of a sudden you have a defamation case that is moving its way through the courts, and you have a July 15th release date, and you can't hit that because a judge won't release it out of pretrial emergency. It's called an emergency TRO, an emergency temporary restraining order. And that's going to freak studios out. So they're going to do it out of an abundance of caution for defamation concerns. And then also copyright and trademark. We'll talk about that in a second. And then when I say abundance of caution, there are some really dumb federal judges. There's some really dumb state judges. And I say this as a lawyer with the utmost respect for people who hone, on the bench. Let me give you an example. When I was in law school, I interned for the district attorney's office to kind of get some actual courtroom experience. And in district court, you have judges putting people on probation and putting people on parole and doing pretrial motions, all this other stuff. I was a third-year law student. I had only been at the DA's office for 6 months, working 2 to 3 days a week, really not a whole lot. And some of the judges were so ignorant of the law that a third-year law student had to explain to them how probation worked. And I am not even a little bit joking about this. And this is not something that is limited to the Guilford County District Courtroom. You're going to see it in Superior Court. You're going to see it on the Court of Appeals. And God love democracy, but especially in places where you have democratically elected judges, you're going to see it on the state Supreme Court as well. And so this is stuff that I expect you guys to know, right? It's expressive work. Right of publicity doesn't apply. The First Amendment protects against that. I do not expect that there is a very real possibility that an idiot district judge grants the celebrity's motion because they don't understand the law. And so that's going to be one of those abundance of caution things that we talk about. Now, I have the slide up here. Hopefully you guys can see it. Please don't know if you can't. Who's the guy? There are all these Muppets. And then who's the guy in that picture? Does anybody know? Muppet Show. All right. It's Jim Henson. So Jim Henson died, and he also, was responsible for the Sesame Street and Fraggle Rock, a lot of things that the kids still grow up on now. There was something called the Hollywood Blacklist, and it's different than the Hollywood Blacklist that was during the McCarthy era during the 1950s and the 1960s. This was the Hollywood Blacklist that has risen up over the past 15 to 20 years. Again, does anybody have any idea what the Hollywood Blacklist is as it currently exists? Okay. So Hollywood Blacklist is a list of unproduced screenplays. So it's essentially a list of the best unproduced screenplays currently in Hollywood. And for a number of years, a biopic about Jim Henson, creator of the Muppets, creator of Fraggle Rock, was on the top of it. but everybody knew it wasn't going to get made. And it's not because you can stop making a movie about Jim Henson. We've seen people have movies made about them already, right? Steve Jobs, Mark Zuckerberg, all of the presidents, right? You have, we talked about the Devil Wears Prada that has a thinly veiled reference to Anna Wintour, right? You know, like most movies right now are biopics. If you want to get nominated for an Oscar, you put on a silly accent and you place a famous person. So like those are the things that you know are very real. But the reason Jim Henson's can't get made is because you can't own the rights to Jim Henson's life. But you know what you can own the music or rights to? The Muppets. They're copyrightable. Or the Muppet Show theme song. Does anybody want to watch a Jim Henson movie that doesn't have the Muppets in it? Does anybody want to watch a Jim Henson movie that doesn't have the Muppet Show theme in it? And the answer is no. And that's the issue that you ran into with the Queen biopic. For the life of me, I can't remember what it's called now. Bohemian Rhapsody. And Rami Malek got nominated, or I think he won an Oscar for it. And I didn't see the movie because I heard it was not great, but apparently there is a scene where Brian May and another member of Queen, the ones who are still alive, were at a party where there was lots of things going on, like cocaine and women and everything like that. And they very clearly go, guys, this isn't for me. I have a wife and kids at home. I'm going home. Goodbye. And they leave all the debauchery to Freddie Mercury and whoever else was there. And it is very clear that that was input by Brian May. And so the question becomes, well, why the heck do the producers of Bohemian Rhapsody care what Brian May, the member of Queen, care? Why do they care? I mean, the answer is that because Brian May doesn't own the rights to his own life, but he definitely owns the rights to We Are the Champions or Bohemian Rhapsody or whatever else you have from Queen, right? And so those are going to be the things you really have to think about. You have to think about these things in combination. So, all right, so this slide is essentially kind of summarizing what we've already talked about. First Amendment protects news gathering. It protects expressive work. It protects artistry. And if you prevent a celebrity, including politicians, from, if you allow them to prevent their likeness being used in any way, shape, or form, then think about how far that could be taken. President Trump or President Biden could say, I own the likeness to my face, which is true. And you know what, New York Times, do you know what Fox News, do you know what CNN, I don't want you to ever use my face, because I own my face. It means we could have a situation in which a newspaper or a television station could not show a picture of the President of the United States. That's obviously idiotic, that's obviously silly, and cannot be the purpose of right of publicity laws. So when it comes to news gathering, you have the First Amendment protection, and also under most laws, they're not going to meet the test anyway because, as we've already had point out, those are not strictly commercial interests. Now, the other defenses you can have, parody. We'll talk about parody a little bit later on when we get to copyright as a defense to copyright. In the case, I really like this case, and it really illustrates what is a parody. A parody is not simply a funny version of something, okay? A lot of times when I see people talk about fair use or defenses or these types of things online, they'll say fair use parody, right? Fair use parody is if like they can just wave the magic parody wand and all of a sudden whatever they decide to do is fine. Parody has a very specific meaning. Parody is a criticism of, it is a mockery, it is a criticism, it is making fun of a particular thing. It is not simply a version of it. So here's an example of what I'm talking about. Dillard's, when there used to be department stores, which it seems as though there are not now, they were trying to sell Henleys. Henley's a type of shirt. You'll see it on the guy on the right. It's a long sleeve. It has like 3 buttons. It looks essentially like a long sleeve polo shirt. Don Henley is a famous musician. Not entirely familiar with his work, but you can ask my parents, right? They kind of know who, you know, and so with, you know, famous musicians. So Henley, right? You can kind of see where this is going. And as you'll see in the slide, Dillard's released an ad and it said, "This is Don, and this is Don's Henley." Ha ha ha, everybody finds it funny. Don Henley didn't find it funny, and he sued, saying, "You violated my right of publicity." And Dillard's raised a fair use defense, saying, "Look, Don, we are making fun of you, right? This is a parody." And the court said, "What's the joke? Are you making fun of him because he has a name the same as a shirt? That's not really a joke. The joke is wordplay. The joke is a pun. The joke is a dad joke. And a dad joke is not a parody. A play on words is not a parody because it doesn't criticize or not demean necessarily, it doesn't criticize or make a mockery of Don Henley. It just points out the fact that his name is the same as another person's name." I've got a cat coming in. Please hold. You want in? All right. These are what happens. This is what happens when we work from home. So, and so when we're talking about a parody, and we're going to be talking about this in a lot of context over the rest of the semester. So I want you to keep that in mind as well. Everybody say hi to my cat. She's very clingy. Okay. So now the other defense that you can have is essentially it's called a fleeting or incidental use defense, right? If a celebrity is only in it for a couple of minutes, or not a couple of minutes, just like a very fleeting, very, very, you know, very brief reference, well, that's not going to be considered violative of somebody's right of publicity. Sorry, right of publicity for two reasons. Number one, there's not going to be commercial advantage, right? So one of the things that we'll see is if like you have a celebrity in the background of an advertisement, or you know a very brief reference, and nobody really understands that the celebrity is there, or makes the association that the celebrity is endorsing a product or anything like that, then there's no commercial advantage, because if people aren't aware of the celebrity's presence, then how can the alleged infringer be benefiting from it in any way, shape, or form? Number two, you look at the damage to the plaintiff, the damage to the celebrity. If nobody is really aware that the celebrity is involved, then their value isn't diluted in any way, okay? They're not going to have any injury there. So really, it's listed as a defense, but it's maybe a little bit better to look at it as it just simply doesn't meet the test, because there's no commercial advantage that is going to be gained by plaintiff. Now, why do I have NCAA football up here? A number of years ago, there were, and I believe it's coming back actually, but there were college basketball games for the PlayStation. There were college football games for the PlayStation, and they were really big, right? You could run your own North Carolina basketball team, and everybody really liked it. And they used real players, so you could play as Tim Tebow, or you could play as Tyler Hansbrough. You could play as you know, all of these, you know, your favorite college basketball players, and these players weren't getting paid because college basketball players aren't allowed to get paid because there's amateurism there. And but they sued, saying, "Look, EA Sports, look, UNC, look, NCAA, look at all these people. Like, you are making money off of our likeness. You are selling more video games because Tim Tebow is in it." And the court looked at it and they agreed. They were saying, look, there's a commercial advantage here. And what they did, which I found really interesting, is for video games like NCAA football, or like basketball, right? You know, those like sports games, those are going to be considered different than things like The Last of Us or Grand Theft Auto or Journey, those highly artistic storytelling games. These games are more like simulators. You play FIFA, you play NCAA football because you want to simulate what it is like to play as your favorite soccer or basketball team. And so that is going to be a defining feature. It might be, although I'm not entirely sure because it's not a heavily litigated point, if you had a celebrity who was in a video game in more of an expressive, right? So if you were doing it in kind of a more storytelling-based video game, that might be a little bit different. And so the court found this wasn't a fleeting reference, right? These players were featured heavily in the advertising. They were significant and focal points of the video game. And so that is why we don't have NCAA football or NBA or NCAA basketball on video games anymore. Now, I believe they're making a comeback, but I'm going to almost guarantee you one of two things is going to happen. Either with the NCAA loosening amateurism rules, these players are going to get paid, or you're going to have stand-in filler players, and instead you'll be able to run the Alabama football team, but you are not going to be able to use real Alabama football players in order to make that happen. They're essentially be filler players. And we see that with some other video games as well. All right, that is right of publicity and all of the rights that celebrities have. Does anybody have any questions? All right, cool. All right, so let's talk about copyright. Copyright is going to be probably the thing that, for those of you who do not want to go into news gathering, going to be the most important thing that you guys need to be aware of when you embark on your career as a filmmaker or a screenwriter or an editor. But copyright is one of those things that is so little understood, for better or for worse, but it is. So let's kind of walk through exactly what it is, and hopefully you'll have a better idea, because we're going to spend about 2 weeks on this. Because I think it's, like I said, probably the most important topic that we have in this class. Let's define it first. Copyright is defined as the exclusive legal right given to an originator or assignee to print, publish, perform, fill, or record literary, artistic, or musical material, and to authorize others to do the same. Okay, so that is very legal mumbo jumbo. Let's kind of look at it in its individual parts. Number one, it is an exclusive right available only to the individual who owns the copyright. It is for performance or reproduction of material. And it is going to be for a limited time. Okay, let's work through those things individually. But before we get to that, let's talk about the source of law. This actually comes, you guys are not going to find this nearly as interesting or nearly as exciting as I do. This actually comes from the Constitution. It's going to be Article 1, which is the powers given to Congress, because Article 1 is legislative powers under the Constitution, Article 2 is executive powers, and Article 3 is the judiciary. So this is Article 1, Section 8. And it states that, quote, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, before we get any further, copyright does not only apply to written words. Okay, it's going to apply to pretty much everything that is going to be considered a creative expenditure. So filmmaking, photography, dance, sculpture, even clothing, as we'll see a little bit later on in class. All of these things are going to be considered actual writings. Now, it also protects inventions and discoveries. Does anybody have any idea what the source of law for those are? Exactly, patent. Alice says patent. That's correct, right? We are not dealing with patents. And what we'll see is that patents and copyrights are mutually exclusive. And I'm going to go so far to say that if you get a patent on something, it by definition means that you cannot get a copyright on it. They are there you have two circles. There is no Venn diagram there, where you have a little slice in the middle where they overlap. They are two separate entities that are mutually exclusive. Little bit of trivia. Sure, nobody else cares. This was done because you would have states like Rhode Island just like stealing stuff from Massachusetts and be like, don't really care. What are you gonna do about it? I'm a sovereign state. Are you gonna call the army in on me because I copied somebody else's writings? No. And the copyright was originally part of the Secretary of State's office. Now, I will be very impressed, or at least thinking that somebody is as big a fan of musical theater as I am. Does anybody know who the first Secretary of State in the United States was? He's got a monument in Washington. Thomas Jefferson. Exactly, Alice. Thomas Jefferson. So he was the first holder of copyright. Now, is that the thing he's known for? No. Do I find it super interesting? Yes, I do. So this is federal law. And Congress is given original jurisdiction over it. When we're looking at things like trademark, when we're looking at things, that have really, or the FCC, or these kind of federal agencies that cover a lot of what we've talked about in this class so far, the source of power is going to be like the Commerce Clause or some other areas of the Constitution. This is something that is actually specifically listed in the Constitution as a power given to Congress, which I find interesting. Now, what can be copyrighted? Under 17 USC 102, you will not be expected to remember that, but that's where it is. Copyright subsists of, quote, original works of authorship fixed in any tangible medium of expression from which they can be perceived, reproduced, or otherwise communicated. Now, that creates two distinct requirements here: originality and tangible medium. Now, copyrights cannot be denied on the basis of obscenity or fraud. Now, obscenity can be banned. Fraud is illegal. But the US Copyright Office is unable, as a matter of law, to say, this is offensive, this is horrible, this is obscene, we are not going to register this copyright. Nothing to do with it. As long as it is original, and as long as it is fixed in a tangible medium of expression, good to go. So the example I always use is Mein Kampf, right? If Mein Kampf, Hitler's manifesto, was written in the United States today, and there are things just as terrible being written in the United States today, and that person really wants to copyright their hate-filled, their hate-filled bigotry, they can go down to the Copyright Office and say, hey, guys, I got this super offensive thing. I'd like to register for copyright. They'll say, sure, that's okay. Now, if it's obscene, can the government arrest them? Yeah. If it is obtained fraudulently, can the government arrest them? Yeah. If it is, violates any of the other exceptions to the First Amendment, the government can ban it. The government can arrest somebody for distributing it or whatever else, but they can't, the Copyright Office will not be looking at the content and making a determination as to the legality or the illegality of the speech. So long as it is original, and so long as it is in a fixable, tangible medium, they are good to go. Now, examples of copyrightable material are literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, sound recording, and architectural works. Now, thankfully, we will not be looking at a few of these. We will not be looking at pantomimes and choreographic works, and we will not really be looking at architectural works, although you do have some interesting reading if you ever want to feature a building in your movie or television show, because theoretically, you might not be able to show a particular building. But a little bit beyond the scope of this class. Okay, so we only have two requirements for copyright protection, as I mentioned: originality and fixed medium. So let's look at, and this is something I always really enjoy. And then we watch the Super Bowl or an NFL game, And the following message comes on.
Nice.
This telecast is copyrighted by the NFL for the private use of our audience. Any other use of this telecast or of any pictures, descriptions, or accounts of the game without the NFL's consent is prohibited.
Remember to turn my mute back off this time. Good. So, the NFL has that, right? This broadcast is for the exclusive use of our audience. Nobody may any accounts of the game or distribution or recording or whatever else is without the NFL's express written consent is prohibited. Now, some of those are true, right? I can't illegally stream the NFL game. I can't show it in my bar or restaurant without paying the NFL a hefty sum in order to do so. However, does anybody think that it is possible that the NFL is going to be able to stop me from talking about the game on Facebook or writing an article describing exactly what happened in the Super Bowl? No. So that's pretty darn broad. So we'll look at ways in which the NFL is correct and what they can prohibit being shown, and ways in which that the NFL is maybe not so correct. Okay, so first off, originality. To qualify for copyright, works must contain, quote, at least a minimal amount of creativities. So things like names, titles, short phrases, expressions, or, these are all things that lack the originality requirement to be copyrighted. Now, they can be trademarked, but we'll see a little bit later on, under copyright law, there is not a darn thing in the world that is stopping me from going out tomorrow and making Star Wars Episode 10. Nothing. Disney can't do a thing to stop me under copyright law. Now, under copyright law, I wouldn't be able to use Luke or Leia or Tatooine or A Galaxy Far, Far Away or the Millennium Falcon or any of these other things that do have copyright protection. If I wanted to make my own Star Wars movie about Star Wars, perfectly okay. They're going to sue the crap out of me for trademark, which we'll talk about in a couple of weeks. But under copyright law, they're going to be okay because titles and short phrases aren't original. And you don't get copyright in something that you are not the originator of. Now, does anybody have one of these t-shirts, the ones on the left, those North Carolina home ones? You'll see those a lot just around, right? They're around a lot. And when those first started getting popular back in like 2012, 2013, there was a big rush for individuals to try and copyright them, saying, look, I'd like a copyright protection in North Carolina with home on it, or North Carolina and run, or beer, or beach, or whatever else you want to put on it. And the Copyright Office essentially said, this is an original. Okay, this is not an original piece of authorship because there's really not a lot of creativity here. Now, right, I understand that it's aesthetically pleasing and all of that fun stuff, but all you did was take the North Carolina shape, which you don't own, and you put the word home on it, which is a single word of the English language. And putting those two things together is not sufficiently original to qualify for copyright protection. So anybody can go and make their own North Carolina home t-shirt. It's not original and therefore does not qualify for copyright protection. So there doesn't have to be a lot of creativity. There doesn't have to be a lot of artistry. There doesn't have to be a lot of any of that stuff. But there has to be at least a minimal amount of it in order to qualify for copyright. Additionally, ideas, methods, and systems are explicitly outside the scope of copyright. It's actually listed in copyright law. So an example for this is recipes. We can all agree that mom's lasagna is not going to be copyrightable. You can't just show up and say, because you are not the first, your mom, I'm sure, as great as her lasagna isn't highly original. Chances are, right? It's probably got meat and onions and everything else. And even if it is highly original, it's probably not creative. Instead, there's a practical purpose behind it. paste or whatever else. So, but writings are copyrightable, but copyright law makes explicit that recipes are just lists of how to make something uncopyrightable. In the same way that your IKEA instructions are not copyrightable because they just tell you how to assemble a chair. So these are not going to be considered copyright either because they simply describe something non-copyrightable. Now, what does copyright protect? Copyright protects only expression, not the ideas or the facts contained in that expression. So the example that I use is the movie Lincoln, okay? Now, there's going to be a lot of the movie Lincoln that is going to be copyrightable. I can't just steal it and put my own movie in there. And that is going to be because there are aspects of it that are copyrightable, right? The cinematography is highly creative and highly original. The screenplay is highly original and highly creative, like the actual dialogue choices. Maybe the performance by Daniel Day-Lewis. That's not always clear whether or not acting can be considered copyrightable, but let's assume for the sake of this argument that it is. The costumes, so there's gonna be a lot about it's copyrightable, but do you know what's not copyrightable? The fact that Lincoln lived, and he was the 16th president of the United States, and he was the president during the Civil War, and he drafted the Emancipation Proclamation and tried to get the 13th Amendment passed through Congress. Like, those things are not copyrightable. So that's going to be something that you want to keep in mind as well. So copyright does not protect facts, no matter how juicy they are. However, they can protect the arrangement of facts or how certain facts are selected and incorporated. So let's keep on with the Lincoln example here, right? So with Lincoln, it is based on a book called Team of Rivals by Doris Kearns Goodwin. Now, not nothing, but very little in Doris Kearns Goodwin's book is going to be copyrightable. Again, she doesn't own a copyright on the fact that Lincoln existed and that his wife maybe had some mental health issues and had a complicated relationship with his son, and blah, 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 right? That is not something that Doris Kearns Goodwin could own, and even if she could, would not be the originator of. So she would not be the original person to talk about how Lincoln existed. And so, but obviously her book is going to have a copyright interest in it. And that is because the facts that exist, she doesn't own, but selecting certain facts and omitting certain other facts and ordering them in the way that she did. She also theorized about how certain conversations went, or who was able to talk to who. So that's kind of the other things that I want you to be really aware of is when you select certain facts and you select them in a creative way, then that can be copyrightable. So let me give you an example again of what I'm talking about. There's a website called Box Office Mojo. Box Office Mojo literally just has box office receipts for various years. That's really interesting. You can go back and see, hey, I wonder what the #1 movie in America was the day I was born. It's a fun experiment. You should do it. I wish I remembered mine right now. Don't remember what it is. But with, sorry, I was thinking about what my movie, I think it was Terminator 2? I don't know. This is not a productive live conversation. So with Box Office Mojo, you can look back on any year, but it's very simple and it's not very creative, right? What's the most effective way to list box office receipts? It's whatever movie made the most in a given year to whatever movie made the least in a given year or on a given weekend. And so the ordering is not inherently creative. But that's the difference between, say, Doris Kearns Goodwin and Box Office Mojo. Doris Kearns Goodwin exercised creativity. She exercised originality. She exercised editorial and creative control over a team of rivals. Box Office Mojo is essentially just an information aggregator, and they're going to take that information and they're going to order it in the most simple way. So let's look at another example. The New York Times is going to own a copyright in their articles. They're going to own a copyright in how their newspaper is ordered and where picture goes where, like the design of the newspaper. They're going to own a copyright in all of that because that is an expression of work. That is going to be an expression of the underlying facts. But if the New York Times writes an article about Donald Trump's taxes and has all this new information that the New York Times found, then they don't own that. So if they discover, and I'm not saying it's true or not, but that Donald Trump only paid X number of dollars in taxes in a given year, there's nothing stopping ABC from saying the New York Times is reporting that Donald Trump paid X number of taxes in a year. They don't get to hide that information behind a paywall on NewYorkTimes.com because they don't own that fact. Even if they discovered it, they don't own that fact. And before anybody asks, you can't patent a fact either. Okay, you can't patent a fact. You can't patent a actual discovery. You can patent inventions, cannot patent discoveries. Like if you find a dinosaur bone out somewhere, you don't get to say, I own this, I get to patent this dinosaur bone. So that's going to be something else that you really need to look at, is that when you're talking about facts that can't be copyrightable, it's the ordering, it's the expression of those facts that can be. There is also not something called the sweat of the brow exception. And this comes from a case involving phone books, which I can't think of the last time I used a phone book. 1999, maybe? I imagine most of you guys have never, ever used a phone book, and I don't blame you. It's very outdated. But, we still get them some reason, right? Those big yellow things that come and sit on people's doorsteps until they move. There was a case in which one company expended a lot of money and a lot of resources to get everybody's phone number in a given area and put it in a book and ordered it alphabetically. And then another telephone company was like, oh, that sounds good. I'll just copy and paste that. I'm going to just copy it. I'm going to put it in my own phone book, and I'm going to distribute it as well. And the original phone company sued, saying, we spent all of this money in order to discover these people's addresses and these phone numbers and order them and all of this other stuff. And the court said, yeah, that's great, but it's not copyright because it's just facts, right? The facts are you had this, Adam Adamson has this phone number and lives at this address, and it makes a lot of sense to order it alphabetically. Like, there's no creativity there. This is a different thing than the UK. In the United Kingdom, there is the sweat of the brow exception. It says that if you expend a lot of money, a lot of resources in order to discover facts, that you have some amount of control over those facts. That is not something the United States recognizes. So that's another difference between the two countries. Okay. Now, collective works are going to be a little bit different than compilations. Compilations are going to be a gathering or a bringing together of uncopyrightable material. Facts, ideas, processes, those sorts of things. Collective works are the order and selection of individually licensed copyrightable material. And the copyright that exists in these works is for the expression found in the editing and formatting of another copyrighted work. So let's give an example of that. When I was in high school, like Garden State was a really big deal. It was like an indie movie, and everybody really, at least 16-year-old me really liked it because it was different and indie. I'm kind of afraid to go back and watch it now because I'm really afraid it doesn't hold up. But a big part of Garden State the movie was the soundtrack. And when Zach Braff, the director, decided to make the soundtrack, he didn't own a copyright in the Simon & Garfunkel song that is in there. He didn't own the copyright in the Frou Frou song that was in there, or the 07 song that was in there. Imogen Heap, or what her name is, owned the copyright. Simon & Garfunkel owned the copyright in Only Living Boy in New York. So Zach Braff doesn't get a copyright in something that somebody else created. But the fact that he included one Simon & Garfunkel song but didn't include another, or they put the Simon & Garfunkel song after the 07 song but before the Frou Frou song, right? That order and selection, he is going to have a copyright interest in. So how does this play out in the real world? Let's say I were to go to Simon & Garfunkel and get a license to put a Only Living Boy in New York in a soundtrack. And then I go to Frou Frou, do the same thing. And I go to all these various bands and I get the exact same licenses that Zach Braff got. I cannot then release my own identical version of the Garden State soundtrack because Zach Braff doesn't own a copyright in the underlying works. But that order, that selection, that is an exercise in creativity. And therefore, he gets a copyright interest in that. Now we get to something that I find really interesting. I mean, I find all this interesting, but this is something that I really find interesting. And it's called derivative works. And we have a big, long explanation on the left side of the screen, but I'm not going to make you read all that. Bottom line is this. Derivative works are works that add something new on to a pre-existing copyrightable work. So what we're going to do, because I'm still using this one because we haven't had any new movies come out since this one came out, just about, which I'm not bitter about at all. We have Avengers Endgame. I'm currently doing a Marvel rewatch and building to this. And so with Avengers Endgame, we're going to watch the trailer. And I apologize if anybody gets spoiled. It's been out 2 years. At a certain point, it's on you. But I want you guys to watch the trailer, and I want you to think about all the things that are in the trailer that already existed before the trailer came out, right? What does it include that is not original to the trailer, that predates it or is a byproduct of it? Listen and watch, and then we'll come back and we will talk about how the trailer, and we're talking about the trailer itself, not the movie, but the trailer itself, how the trailer is a derivative work.
God, seems like 1,000 years ago. I fought my way out of that cave, became Iron Man. Realized I loved you. I know I said no more surprises, but I was really hoping to pull off one last one.
The world has changed. None of us can go back. All we can do is our best. And sometimes the best that we can do is to start over.
I saw all these people die. I keep telling everybody they should move on. Some do, but not us.
Even if there's a small chance, we owe this to everyone who's not in this room to try.
We will. Whatever it takes. Whatever it takes.
Whatever it takes.
whatever it takes.
I like this one.
All right, so look at the trailer. What things included in that trailer build upon something that existed before it came out? You can either respond or you can respond in chat, because there are a lot of them, so some of them should be fairly obvious.
I feel like half of
Um,
it is just a recap of like the last movie and just like it's just like building up to it kind of.
Yeah, so I mean, a lot of it includes footage from other movies, right? Avengers: Infinity War or the original Iron Man. Yeah, Jayla?
would it be like derivative in the sense that the characters come from pre-existing comic book lore, or the storyline itself may be
Right.
derivative of a pre-existing comic book?
Yeah, exactly. Marvel movies are based on Marvel comic books. So let's actually look at how many, it's almost like Inception, right? Layer, 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 layer. So you have the Marvel comic book, which became the Marvel movie, which then became the Marvel. So like, let's look at Iron Man. Iron Man was a comic, which then became Iron Man the movie, which then had the sequel, Iron Man 2 and Iron Man 3 and all the Avengers movies, and then eventually leading to Avengers Endgame. And so those are all derivative works. Those are all building upon the thing that came before it. What else? What about the music? Is that music derivative of the previous Avengers theme? Yeah.
Yeah.
Now, it's not exactly the same, and that's really important, right? If you listen to that music that is in the trailer to Endgame, it is different than the original Avengers theme. It's similar, but it takes the original and it builds upon it. Now, is any trailer a derivative work? The answer is yes. A trailer is a derivative work of the movie itself. You have the movie, and then the trailer builds upon the movie by creating a condensed version to get people to see it. A movie itself is a derivative work because it is a derivative of the screenplay upon which it is based. The examples are movie to screenplay, screenplay to novel, sequel to original, reboot of a pre-existing work, translation of a literary work, redaction, condensation, dramatization, or adaptations. Now, again, I'm not expecting you to remember this entire thing, but one of them I really do want you to remember, and that is going to be the translation of a literary work or translation of any work. I do not speak multiple languages. I failed Spanish in middle school, I failed French in high school, and I failed Latin in high school. My part of the brain that understands languages does not work. But I know enough to know that translating things is not always, it is not a scientific process, because things don't always translate precisely, right? So you need to have some amount of creativity when you are translating from one language to another. So, for example, if I'm going to watch a Fast and the Furious movie, but for whatever reason I want to watch it in French, and I want to watch it with the French subtitles on, or I want to watch it with the French dubbing on, that is going to be an exercise of derivative works. That is going to be an exercise of creativity that does get copyright protection. So you have a derivative work. What exactly do you get? And I'm going to read it to you guys because I want to read the actual legal mumbo jumbo, and then we'll get into what exactly it means. Now, when we're talking about collective and derivative works, the copyright in a compilation or derivative work extends only to the material contributed by the author of such work, as distinguished from the pre-existing material employed in the work, and does not imply any exclusive right in the pre-existing material. The copyright in such a work is independent of and does not affect or enlarge the scope, duration, ownership, or subsistence of any protection in the pre-existing material. Now, what in the heck does that mean? At the end of the day, it means two things. Number one, that when you create a derivative work, you get a copyrightable separate interest in the new material that you contributed. So when the person who made the Avengers Endgame trailer, they get a copyrightable interest in the trailer itself. That is theirs and their exclusive right. It also means, and this is number two, that when you create a derivative work, you do not all of a sudden magically get a copyrightable interest in in the original thing that it was based on. And the example that I like to use is the extended universe in Star Wars, which now is no longer a thing, and I'm very sad about because it is what I read a lot in childhood. But the extended universe in Star Wars essentially was, we have these characters, we have these planets, we have these copyrightable things. We got Luke, Leia, Tatooine, Millennium Falcon. And authors like Timothy Zahn created their own storylines. They introduced new characters like Grand Admiral Thrawn or Mara Jade. And I know I'm sounding very nerdy right now, but Timothy Zahn, when he created these characters, got a copyrightable interest in Mara Jade, in the story and the setting and all the things that you normally get a copyright interest in the new things that he created. But Timothy Zahn does not own Luke Skywalker or Han Solo or Darth Vader. That's still George Lucas. That's still Lucasfilm. Additionally, by creating a derivative work, you don't get to extend the copyright of the original. So with things like Batman, and we'll talk about Batman and Superman in a little bit, they are going to be entering the public domain in the next 15 years. So in 15 years or so, you're going to be able to make, theoretically, from a copyright perspective, your own Batman movie, write your own Batman comic, write your own Superman comic. It doesn't mean that all of a sudden I can show Justice League whenever I want to, because it has a public domain character in it, because that was made in 2017. I know it can get a little bit finicky. So, and it's not always easy to kind of identify the difference between the two. Just at the end of the day, what you want to remember is any new expression of creativity gets its own copyright, so long as it meets the copyright definition. So that is originality, right? You got to be original. You got to be the originator of this copyrightable material. You got to be the first, and it can't be based on facts. It can't be based on facts. It can't be an idea. It can't be a process. Then you got to show that it's in a fixed medium. Now, for the majority of the time, it's going to be pretty easy to meet. But let's still talk about when copyright attaches, because that might be a little bit different. So the rule is that the work must be fixed in what's called a tangible medium of expression. The example is when a screenplay is when words are typed down onto a computer or written down on a piece of paper. A song is when the sheet music is created or the song is recorded, and a photograph is when the shutter closes on the camera. So if I take my phone out and I take a selfie, which it would be a really bad selfie, the second I hit the shutter and it takes a picture, I get a copyright in it. Now, it's not a very valuable copyright, but it's copyright. So most of the time, this isn't going to be an issue because we live in a world where it's so easy to document everything that we do. But let's look at an example of, and by definition, I can't show you an example of something that doesn't have a fixed medium, because by me being able to show it to you, it's in a fixed medium. So go with me here. It's a little bit of an example. But buskers, people who are playing, street musicians, count as somebody who may not be in a fixed medium.
scratching at the surface now. And I'm trying hard to work it out. If so much is gone misunderstood, and this mystery only leads to doubt.
Okay, so we don't need to do the entire song, but let's say Glenn Hansard, when he wrote that song, or when he performed that song, it was improvised. He never wrote it down. He never copied the lyrics. Nobody was walking by with their phone recording it. He does not get a copyrightable interest in that song because it's not a fixed medium. He performed it and it's out in the ether and it never exists again. So if he hears walking down the street, somebody performing the exact same song as him, he can't sue them. Because what is he suing over? He doesn't own anything. He doesn't have a copyright interest because he never put down his creative expenditure into a fixed medium of expression. All right, now we're going to end today with a conversation about formalities and duration. This is very technical, but really important. So copyright protection, if you have an identifiable author, it goes, and this is for works created after 1975, for the record. It is the life of the author plus 70 years. Okay, so let's look at something like Harry Potter. Harry Potter was created after the 1975 Copyright Act. And so it has a single identifiable author, J.K. Rowling. Harry Potter will be under copyright in the United States until J.K. Rowling dies, which let's say is 2050, right? Let's say she gets another 29 years, plus 70 years. That means that Harry Potter will enter the public domain, and we'll talk about the public domain next class, in 2100, in the year 2120. If you have joint authors, it is going to be measured from the death of the last remaining author. So you honestly have this a lot in bands. If you have 4 people who jointly own a copyright in a song, and one of them dies super young, as musicians are known to do, especially famous ones, then the copyright is going to not go from when, say, Freddie Mercury died, but is going to be measured from when the last surviving member of Queen died. Copyright is an asset. Copyright is a piece of intellectual property. It can be passed down following death. It is why Tolkien still has, this Tolkien estate still has a copyright interest in Lord of the Rings. Now, if you don't have a living author, companies never die, at least not a traditional death, then it's 120 years from the date of creation or 95 years from the date of publication. You are definitely going to have 95 years from the date of publication far more often, because how often do people create something and then sit on it for 25 years? The answer is not very often. So let's say if a studio creates something in 2020, which makes my life a little bit easier for math purposes, it'll enter the public domain in 2115, 95 years from the date of publication. Now, different rules apply for works created, or for when works are created. If works are published from 1925 to 1963, it's 95 years. And we'll talk about that next class when we get back to public domain. Otherwise, it is 6:10. I appreciate you guys being here for online class. I know it's not ideal, certainly not the way I would prefer to be teaching, but we're going to do what's best for everybody, and I will see you all on Wednesday. Thanks.